a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up For You. Today is Friday, November 18th, 2022. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co-founder at Courtroom 5.
Oh, we have a delightful show for you today. In a few moments, we'll speak with Emma Hawley and Melissa Franca, both law students at the University of Wisconsin. We spoke a few days ago with their professor, Charles Von Simson, and so we'll get their perspective on the externship and what they're doing with Courtroom 5. Before we get there, I do want to remind our audience that today is episode number 50, and that means it's the end of the first season of Who Wrote That Up For You. Deborah and I will take something of a break for the next 3 weeks, and we'll visit you again on Monday, December 12th. So I want to make sure everyone marks their calendars for our return and the beginning of season 2 of Who Wrote That Up For You on December 12th. But Deborah, what is on your mind today? What is our issue of the day?
I want to talk about this judge in Mississippi who's had a complaint filed against him for not turning over search warrants to the clerk. Now, you know, when a judge sits on the bench, he might make an order and he might sign that order. But if he doesn't send it to the clerk's office, it's procedurally incorrect. Okay, any order is supposed to go through the clerk's office. But in good old Greenville, Mississippi, the Cliff Johnson of the Mississippi Office of the MacArthur Justice Center filed a complaint against Judge Pruitt with the State Judicial Commission because he's signing these orders. They're multiple no-knock orders, search warrants, without filing them with the clerk. That means that procedurally they are incorrect. And so they have people barging into folks' houses and serving them these warrants unannounced, and these warrants are not procedurally correct. And so Mr. Johnson wants the state Supreme Court to do something about that.
Wow. That is a big deal. You know, we've had our experiences in the civil system where a pro se litigant makes some simple, trivial mistake. You might miss a rule. And it is a 4-alarm fire in the experiences we've had. Something, you forgot to tell the judicial assistant something, that the rule required. It's terrible. But we've seen lots of cases where, and we've complained about, the opposing counsel didn't do this or didn't do that, or the judge himself violated a rule. And it's like, it's just it's just guidance. It's not like a rule, right? It's just a simple thing. And so that sort of bias, I'm not surprised to see a judge, ignoring rules they're supposed to follow. But this is a pretty big deal, particularly with a no-knock warrant. That's on the criminal side. I do hope some of the people affected there are taking advantage of this violation of the rule and making a big deal of it. Hopefully that Justice Center makes the judge pay for that. That is a shame. Appreciate you bringing that to our attention, Deborah. Who Wrote That Up For You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my great pleasure to welcome onto the show Emma Hawley, Melissa Franca, law students at the University of Wisconsin School of Law, and they are completing an externship with Courtroom 5. Just wonderful to see you both here. Melissa, Emma, thank you very much for joining us. Let me ask then, first of all, uh, let me see, let me get a picture here that makes sense. Fantastic. Let me ask, let's start with Emma. Emma, you, I think, are a second year law student. What is it that interested you in going to law school? What's your background?
So my background is in engineering. I have a bachelor's in biomedical engineering and a master's in mechanical engineering. And before going to law school, I worked for a medical device company in quality assurance for 3 years. And a lot of the interactions with the regulatory bodies that I thought were really interesting reminded me a lot of kind of interactions with or like that you would see in legal careers. And so that kind of steered me towards looking into law school. And then once I was kind of doing my research, I found out that I could apply my background in engineering in the legal field by um, going into like intellectual property and looking as well. So that is what I hope to do following graduation. And I'm excited to kind of see as I explore the legal fields, like what else is out there as well, and getting opportunities to explore kind of like some non-traditional areas of the law, um, like looking at internships or externships like we have here with Courtroom 5 and kind of being able to apply the problem solving skills that I learned from engineering, and kind of pivot and apply that thought process to looking at the problems that we're seeing here and trying to solve through our externship.
Fantastic. Thank you for that. Emma, how about you, Melissa? Melissa, if I understand, you are a third year law student.
Mhm.
You're on your way out the door here. But
Yeah.
what is it, if you can look back, what is it that got you into law school and your interest in the law?
Yeah, I definitely always had, like, an interest or kind of thought I would end up going to law school, but in undergrad, my major was in business and marketing, and I thought for a while, like, that I would do that, but then I kind of thought about I didn't really enjoy it in the way that I thought I was going to, and what I did enjoy a lot about it, I got really lucky and was able to work with clients, like, in some of my classes, like, in experiential learning credits, and I was able to work with clients, and I realized what I really enjoyed about marketing was like working with clients and even like doing the research, which is what being a lawyer is mostly all about. And I think like being a lawyer, it's more too than like being client facing. Like I do like that's what I enjoy, like talking to people, like getting down to like what they need from me. And being a lawyer is like actually being able to materially help someone versus like helping a business. Or I mean, as a lawyer, you would do that too, but like my goal is kind of to materially help people.
Extraordinary. That's fantastic, and I can tell just from having worked with you all that you both have that interest in serving people. Let me ask. Let's start with Melissa here. What have you learned then in the application process to law school, and then in the courses in your curriculum? What have you learned that's helped shape your understanding of the law, maybe from what it used to be when you were first applying? And how does it set you up for the careers that you hope to have?
Yeah, I definitely thought I had a better understanding of like the law in law school than I did before I applied and came. The application process is like super daunting, and it was not terrible, but definitely like being in law school has really changed my perspective. Like, and I've talked about this a lot with like the people that I'm in class with. It really like you hear about things always and like how the like criminal justice system is unfair, like even civil like litigation, like a lot of things seem unfair, but you don't really know like the nitty gritty of why. Um and once you do learn that, it like really changes your perspective on things, and it like changes your worldview for sure. And that's definitely something that like I faced like really head on during my first year of law school, and now it's something that I think about a lot, but it's something that I've kind of come to like peace with.
Fantastic. I'll follow up on that in just a second. But Emma, how about you? How is the application process and the curriculum in law school shaped your understanding of the law and how you want to practice it?
Yeah, I think similarly to Melissa, I thought that I had a much better understanding of the world around me than I really did. So it's been a really interesting time kind of seeing, like, I think it's really valuable to know what you know and know what you don't know. And there's so much that I thought I knew and I don't. So it's really fun to kind of, like she was saying, dig into the why and try to understand a little bit more. And something I think that through classes that aren't necessarily like on the syllabus, but something that I've gained that is incorporated in many of our classes is just being comfortable disagreeing with people and being comfortable explaining why you disagree, and knowing that like certain things you might not like materially change people's mind about, but being able to explain your side of things and really know that they're hearing what you're saying and trying to process your point of view is something that I think that I've learned to value a lot more than necessarily just than just agreeing with 100% of the things that like somebody says, because you are going to have different opinions, but just figuring out how to navigate those waters, I think is a really interesting thing that you face like every day in law school, and you kind of have to get good at.
You know, and so I want to follow up on both of these. We had a really interesting show, in my opinion, yesterday. We had an attorney, practicing attorney, who acknowledged quite candidly that oftentimes in the court she practices in, there are pro se litigants versus attorneys, and she obviously, attorneys know a lot more about navigating that system. They may have some familiarity with the judge and the court staff and legal procedure, civil procedure, that gives them just an innate advantage, right, over someone, a lay person trying to manage their cases. And so it's incumbent, just as a person, to try to be fair, to try not to use those advantages to the detriment of the system, at least. But at the same time, you've got to represent your client. You've got to advocate your client's interest. And so there was that difficulty. And then later in the show, we spoke with a pro se litigant who's been in court a lot and who had some pretty strong opinions on whether lawyers even ought to be allowed in small claims court, the people's court, if you will, right? And that as a consequence, if we could get rid of lawyers and simplify the procedures so that average people could capably represent themselves, that would be better for everyone. And so it's a really interesting juxtaposition there. And I just want to ask you then, as you prepare to practice law, you don't know whether you're going to end up in court and litigating against pro se litigants, but just the way you've the coursework that you've had, I wonder if you have an opinion there on whether it is possible to simplify the practice of law for lay people, for pro se litigants, at least in some courts, right? And how you would handle that difficulty of trying to advocate for a client and being fair to a pro se litigant on the other side. There's a lot in there, so take what you will. Let's start with Melissa. How would you handle all of that? What's your opinion?
I definitely, and like in the past, have thought about this a lot. I do think that things are way too complicated for no reason. It's definitely more of like a barrier to entry, I feel like sometimes, and like a way that lawyers are able to, stay practicing law. And it's difficult because there is like a lot of nuance, and it is something that would be difficult to kind of reorganize and like reorient. I think in a small claims court, that would be something that would be easier and like a more realistic thing to tackle. But it is like there is a lot of nuance, I think, to some of these things, and it is easy to say that, yeah, it is a lot easier than it seems, and there is a huge way to simplify it. but do I know how to do it? No. Like, so like, there's like give and take on that. And then I think though too, like when you're like an attorney dealing in things like that, you have to be like a zealous advocate for your client, like even in a small claims court like that, but also trying to like be fair and like not deceitful. Like you can be a zealous advocate and be doing a good job and also being communicative and clear. So I think that's kind of the way to weigh in on it if it's something that you have to face, but it's definitely something that I feel like could change, and it wouldn't be super difficult, but not super easy.
Fantastic, fantastic. What about you, Emma? How do you balance zealous advocacy versus the rights of a pro se litigant in the case? And is it possible to simplify the law so that anyone can practice it?
I think that I guess I'm thinking back to a year ago, even just looking at a first assignment of writing something up for civil procedure and just never having seen it before, knowing that like what I was turning in was garbage. But being able like, but that was like all from what I knew, but getting the feedback and being able to practice and like figure out how to make it better. Like if you don't have anybody giving you that feedback, how are you supposed to know? And obviously the stakes were really low for what I was turning in. Obviously, I wanted to not look dumb to my professor, but it was for participation. So like relative to somebody who's turning something in that it's like their first try ever doing it, that for something in small claims court, like, so if you like that you're having housing depends on is a little bit more important, a little bit more daunting. When we first were getting familiar with the platform of Courtroom 5, I thought that the way that a lot of rules in civil procedure were explained when I was looking at the education piece in the library, I thought were really, really helpful in explaining something that is really confusing. We have to take 2 courses on, like the rules of civil procedure, and explaining it in plain English and kind of hitting on the points that you actually need to know, to be able to be like a productive pro se litigant. I thought that that was a really, really good way to go about it. And honestly, when I was looking at them, I was like, why didn't I have this last year when I was taking the class? Because it was really helpful hearing it explained in a different way that wasn't in really confusing words for these Supreme Court cases that are coming from really like intelligent people who are like used to talking to people with words with a lot of syllables and getting it boiled down to a point of like, okay, what's the rule? What do I need to make sure I do? What do I need to make sure I don't do? Versus all of the kind of like ornate language. I thought it was a lot easier to understand and remember, okay, like this is what I need to know to do it properly, which is very long-winded answer.
Thank you
But
for saying that. The
that's how I
check
feel.
is in the mail, right? That is Deborah's work, and so we've heard
It's really
that.
great.
That's fantastic. Thank you so much for saying that. So I should say this is a great segue. The next few minutes, just want to capture the work that you're doing with Courtroom 5. Grateful to both of you. We don't pay you at all. You have selected Courtroom 5 to do your externship with. Tell us about the externship. This is actually a course that you're taking at the University of Wisconsin. Either of you, Melissa, Emma, take it away.
I can start. So I learned about it through Charlie, who was on the podcast, I think, last week. And he is super excited about the legal tech space in general. And so makes all of these really cool contacts at cool legal tech startups. And we got to look at, you know, kind of the options that we had and figure out which one was interesting to us. And just basically, but then we got matched up based on our resumes and like our previous experience. And then what we're doing now, I will let Melissa talk about.
Yeah.
That's
So
okay.
for the that's okay. So for the class, we do have like classes every Friday. I'll like talk about that before like the courtroom 5 experience. So we have classes every Friday, and we read a book called Tomorrow's Lawyer, and which was super interesting. And we did like a book club kind of series on that, as well as we had all the founders from all of the companies that everyone is working for come in and speak. For a class, and we've also had some other speakers from other legal tech startups that people aren't working at, which has been super helpful and cool. And it's kind of really exciting to be able to like pick the brain of like entrepreneurs who are like in the space, because it is something that's so new and like so like there's so much opportunity and cool ideas, and it is really cool to be able to like talk to these people who are on the ground floor of it. And then when it comes to courtroom 5, we've been working a lot on the connection between the attorney, like potential attorneys doing like limited scope services, and the pro se litigants. So that's been really cool, kind of trying to bridge the gap of what's the best way for them to communicate.
Fantastic. And I remember speaking with your class, really enjoyed meeting your colleagues there, and yeah, wonderful experience. But Charlie offered us one student from your class, and we saw both of your
both
resumes and your interests. We were like, can we have both of them, please? So just really, really happy that you both were willing to do some work. So let's talk then about the specific assignment for you, the specific work that you're undertaking. Emma, do you want to take off and start with what you all are doing there?
Sure. Yeah. So right now, well, we started out getting just familiar with the platform and kind of focusing on putting ourselves in the shoes of being a pro se litigant, coming in and getting oriented and kind of like the user interface, and kind of talking with Corey and Elena about that and different questions we had, or working things out through that space. And then Elena, who's doing the like tech implementation side of it, kind of seeing what their thought processes are and like how they built it out on the backside was really, really interesting. To know what, like if we had suggestions or questions, what we were going to be able to move around, and what kind of was, okay, this is something we're sticking to XYZ in that respect. So kind of going back and forth and pinballing ideas off of each other. And then we moved now into looking at the specific services that we think will be common, and then parsing out questions that we think will be clear enough to a pro se litigant trying to use the platform, and complex enough and informative enough when answered to give the attorney an accurate picture of where the litigant is in the process of kind of doing the legwork themselves to get to the point of, I want this single discrete task done, and I think that it would be a good idea for me to have an attorney do it. But they've done all of the previous research by themselves to get to that point. So how do we both satisfy getting the attorney the information that they need, and but not overcomplicating it, or like we don't want it to seem like the questions are, we don't want to oversimplify and make it seem like the questions are like are just being redundant for the user either. So kind of boiling that down for different services.
It's an
Um,
iterative process,
yeah.
absolutely. Something that is going to take, but I really love the effort and work that you all have produced on that so far. Melissa, would you add to that? And just where do you see the project going?
Yeah, I feel like it's really interesting and it's definitely taught me a lot about litigation. Because surprisingly in law school you don't learn a lot about like practical skills. Um, so it's been really interesting and I feel like it is though like a really awesome like exercise to be working on. Um, I feel like it's a lot of times we forget that like synthesizing is basically where all of the work is done and that's basically where we're at right now. It's like trying to pull together like what is actually important, how to communicate between the pro se and the attorney, and like what is meaningful communication between them, and even like kind of nitpicky things like one thing was oh, like having like a character limit on one of the questions, and it's like probably not, like it seems like it would be a good idea because then someone wouldn't rant, but maybe what they then decide is important is what is not important at all. So like it's really thinking about every kind of scenario more than thinking of like, oh, like if someone did this, you kind of have to think of a wide variety of things and kind of think of all the ways that something could go wrong or someone could misunderstand a question, and kind of build out the questions to address those before you run into any issues.
Extraordinary. That's fantastic. As I said, we've really enjoyed your working with us and looking forward to the final deliverables. But we've really benefited so much from your work and your energy and desire to help people. So really appreciate that. Listen, we thank you both for working with us, for coming to share your knowledge and your experience with our listeners here. Obviously, wish you all the best of luck. We're going to try our best to keep you with Courtroom 5 as much as possible. But thank you so much for
Thank
joining us.
you.
Yeah,
You
thank
Thank you
bet.
for having
you.
us.
All right.
Excellent.
Fantastic. Fantastic. Well, Deborah, here on our final episode, you want to tell us about yesterday's quiz and who won?
Yes. Yesterday's quiz was, which of the following is a standard of review on appeal? A, probable cause, B, clearly erroneous, C, preponderance of evidence, or D, reasonable suspicion. And the answer is clearly erroneous. Probable cause and reasonable suspicion are criminal procedure rules, of standards of review, and then preponderance of evidence is a standard of review for a civil case. The winner is Van G. He's won before, but this is a second win for him.
Congratulations to Vanjie there. All
All
right,
right.
fantastic. Well, Deborah, I just at the end of this season one, I just have to give a shout out to all of our wonderful guests, all of the folks who have often at the last minute chosen to give us time and to share their wisdom and their experience, and just to help our audience learn more. We kind of put this concept of a podcast together at the last minute. I'm going to blame you for it all. But we wanted to just sort of create a community of all the wonderful people doing work in access to justice, all the law professors and lawyers who care about the experience of pro se litigants and the access to justice crisis, and oftentimes we've had a number of pro se litigants who are willing to share their experiences with our courts and some suggestions for improvement there as well. And so I think we've done a really interesting thing here in creating that community, at least taking a stab at it. So I'm just really wanting to give some thanks to our guests. We've had some wonderful conversations here.
Yes, I mean, I'm completely impressed because we've been able to just reach into the further regions of the law and the courts and everything. I mean, we've had lawyers, we've had startup founders, we've had court expert witnesses, we've had these students today, and then the Delaney earlier in the week, and teachers, and I mean, it's just run the gamut, and I'm just really, really, totally impressed. I mean, we've had some great, wonderful conversations, and there are just so many people out there who are willing to just provide this type of information to people, and I just love it.
I'm looking forward to season two and the just the wealth of people out there who are lined up to speak with us on this show. So I also want to just give a quick shout out to you. Thank you for the daily quizzes. The challenges there have been really instructional, even to me. And I know we've heard from members of our audience, even some lawyers who like I didn't remember the answer to that too. So thank you. Thank you for having those available for us throughout the season, as well as for having a nice topic to chat about at the very beginning to kick off each show. I was surprised on occasion to hear the correspondence between what you wanted to talk about and what some of our guests wanted to talk about. I know that was coincidence, but I want to thank you
Yes.
for just bringing a number of those issues to light there.
And thank you for being an awesome super host.
Oh, I love
It's
that.
been a
That's
great journey.
wonderful, wonderful person. So we will start up again on December 12th. Everybody, we're going to take 3 weeks off here, and we will see you again on Monday, December 12th. Thanks for tuning in to season one of Who Wrote That Up for You, and we will see you again soon.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.